Okay, good evening, everyone. We are on the record. Today is Wednesday, the 9th day of February in the year 2022. This is a city council meeting of the Jersey City Municipal Council. We had a 6 p.m. start. The clock on my cell phone is showing 6:04 p.m. May we have a roll call for the commencement of this meeting? Councilperson Ridley.
Here.
Councilperson Prinzeri.
Here.
Councilperson Baggiano. Councilperson Saleh.
Here.
Councilperson Solomon.
Here.
Councilperson Gilmore.
Here.
Councilperson DeGise.
Here.
Councilperson Rivera.
Here.
And Council President Waterman.
Here.
We have all 9 council members in attendance at 6:04 p.m. Can we kindly rise for a moment of silence, please? Thank you very much. Kindly remain standing as we salute the flag. I pledge allegiance
To the flag of the United States of America, and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you very much. On behalf of Council President Waterman, in accordance with New Jersey Public Laws of 1975, Chapter 231, the Open Public Meetings Act, also known as the Sunshine Law, adequate notice of this meeting has been provided by the posting on the bulletin board of the first floor of City Hall, the annual notice, which is a schedule of meetings and caucuses of the Municipal Council for the calendar year 2022, and filed in the office of the City Clerk on Thursday, October 28th, 2021. In addition, at its time of its preparation, the agenda of this meeting was similarly disseminated on Thursday, February 3rd, 2022 at 12:40 p.m. to the Municipal Council, Mayor, Business Administrator, Corporation Council, and the local newspapers, and posted on the city's website, so I can certify as to our total compliance with the Sunshine Law. Okay, council members, I'm going to read the first readings into the record, if you would allow me to do so. Starting with item 3.1, City Ordinance 22-012, an ordinance authorizing the acquisition of Block 19002, Lot 7, more commonly known by the street address 287 Pine Street, from the Jersey City Redevelopment Agency. Item 3.2, City Ordinance 22-013, an ordinance supplementing Chapter 332, Vehicles and Traffic, Article 2, Traffic Regulations, Section 332-9, Stop Intersections, to designate Academy Street and Torres Avenue and 18th Street and Cole Street as stop control intersections. Item 3.3, City Ordinance 22-014, an ordinance amending Chapter 296, Street Sidewalks, Public Rights of Way, and Chapter 160, Fees and Charges, Section JJ, Streets and Sidewalks and Public Rights of Way of the Jersey City Municipal Code. Item 3.4, City Ordinance 22-015, an ordinance authorizing the City of Jersey City as a tenant to extend for a 2-year lease with 18 Ash Street Realty as a landlord for space located at 46 State Street, Jersey City. Item 3.5, City Ordinance 22-016, an ordinance authorizing the acquisition by purchase or condemnation of Block 16801, Lot 2, also known as 3-5 Storms Avenue, for the construction of a new park to be known as Fairmont Square Park. And last but not least, item 3.6, City Ordinance 22-017, is an ordinance authorizing the City of Jersey City to purchase from the State of New Jersey Department of Transportation, real property known as parcels 28, 29, 30, 31, 32, 33, 34, 35, 36, 37, 38, and 40 on the NJDOT maps. Council members, before I do that, I believe the BA has a statement.
Thank you, Sean. Council, we're asking to withdraw 2 of these first reading ordinances. The first being 10.3, the ordinance,
3.3.
sorry, 3.3, the ordinance for sidewalks and public right-of-ways, and 3.6, which is the purchase of the properties for DOT. I'll speak briefly on the 3.6, and then Assistant Business Administrator Barker Patel will discuss a little bit more about the sidewalk cafes. Just for 3.6, we're going to just take another look at the map to make sure we have the accuracy with the parcels and give the council a little bit more information on how these parcels are divided. So we're going to withdraw that, and we'll take it back to the council at the following meeting. And Assistant Business Administrator Barker Patel will discuss the sidewalk cafes.
Thank you. Good evening, Council. As we've discussed, we will be amending the fee schedule that was originally proposed in this ordinance. And so we'll be withdrawing this, reintroducing it at the next meeting for a first reading. And the amendments to the fees will result in a significant reduction of the fees that were originally proposed for parklets and sidewalk cafes.
Thank you.
Okay. So council members, with that being said, thank you both BA and Assistant BA. On items 3.1 through 3.6, with the exceptions of 3.3 and 3.6, which have been withdrawn, Councilperson Ridley.
Aye for introduction.
Councilperson Prinzary.
Aye for introduction.
Councilperson Baggiano. Councilperson Baggiano, can you make sure your mic is on? I heard you, but you're really low.
All right.
There you go.
Aye.
There you go. Councilperson Saleh.
Aye for introduction.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye for introduction.
Councilperson Rivera.
Aye.
And Council President Waterman.
Introduction.
City ordinances, item 3.1 through 3.2 are introduced 9-0. 3.3 has been withdrawn. Items 3.4 through 3.5 are introduced 9-0, and item 3.6 has been withdrawn. Alrighty, on to our second reading ordinances. I will read the first second reading ordinance into the record. Item 4.1, City Ordinance 22-004, and a vacation ordinance of the Municipal Council of the City of Jersey City to vacate the portion of 13th Street between Provo Street and Barham Street in the City of Jersey City in the County of Hudson in the State of New Jersey. This is a public hearing on this ordinance. Any member of the public wishing to be heard, please come up to the podium and state your name for the record. Seeing none, may I have a motion to close the public hearing on ordinance 22-004?
Motion.
Motion made by Councilperson Rivera.
Second.
Okay, I'm going to give that second to Councilperson Saleh. On the motion to close the public hearing on City Ordinance 22-004, Councilperson Ridley.
Aye.
Councilperson Prinzary. I don't know if your mic is on.
Aye.
There you go. Councilperson Baggiano.
Aye.
Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman.
Aye.
Motion carries 9-0 to close the public hearing on City Ordinance 22-004. For final consideration and adoption of City Ordinance 22-004, Councilperson Ridley.
Aye.
Councilperson Prinzary.
Aye.
Councilperson Baggiano.
Aye.
Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman.
Aye.
City Ordinance 22-004 is adopted unanimously, 9-0. On to our next second reading ordinance, which is item 4.2, City Ordinance 22-005, an ordinance authorizing the execution of a deed of easement with the 14th Street Florence Street Corporation, permitting the developer to make improvements on a portion of the 12th Street public right-of-way in an area east of Provo Street and continuing on to an area adjacent to the north side of Newport Parkway in connection with the construction of new public pedestrian walkway. This is a public hearing on this ordinance. Any member of the public wishing to be heard, please come up to the podium and state your name for the record.
Motion.
Okay, so no one has come up to the podium. Motion to close the public hearing on City Ordinance 22-005 was made by Councilperson Rivera. May I have a second?
Second.
Second by Councilperson Prince Airy. Loud and clear. On the motion to close the public hearing, Councilperson Ridley.
Aye.
Councilperson Prince Airy.
Aye.
Councilperson Baggiano.
Aye.
Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman.
Aye.
Motion carries 9-0 to close the public hearing on City Ordinance 22-005. For final consideration and adoption of City Ordinance 22-005, Councilperson Ridley.
Aye.
Councilperson Prince Airy.
Aye.
Councilperson Baggiano.
Aye.
Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman.
Aye.
City Ordinance 22-005 is adopted unanimously, 9-0. On to our next second reading ordinance, item 4.3, City Ordinance 22-006, an ordinance by the Municipal Council of the City of Jersey City vacating a portion of Bleecker Street, Jersey City, New Jersey. This is a public hearing on this ordinance. Any member of the public wishing to be heard, please step up to the podium and state your name for the record. And seeing no one
Motion.
coming up, we have a motion to close the public hearing on City Ordinance 22-006 made by Councilperson Rivera. May I have a second?
Second.
I'm going to give that close second to Councilperson Prince Airy. On the motion to close the public hearing on City Ordinance 22-006, Councilperson Ridley.
Aye.
Councilperson Prince Airy.
Aye.
Councilperson Baggiano.
Aye.
Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman. Motion carries 9-0 to close the public hearing on City Ordinance 22-006. For final consideration and adoption of City Ordinance 22-006, Councilperson Ridley.
Aye.
Councilperson Prince Airy.
Aye.
Councilperson Baggiano.
Aye.
Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman.
Aye.
City Ordinance 22-006 is adopted unanimously, 9-0. On to our next second reading ordinance, item 4.4, City Ordinance 22-007 is an ordinance amending Chapter 53, Personnel, Article 7, Workplace Regulations, Section C, Compensation, Article 11, Fixed Salaries, to modify the salary and employment benefits for full-time and part-time aides to councilpersons of the City of Jersey City pursuant to state law. This is a public hearing on this ordinance. Any member of the public wishing to be heard, please step up to the podium and state your name for the record. And I see
Yes, my name is
Jean
Jean
Daly.
Daly.
Jean, just give me 1 second
Sure.
as we
I'll be quick.
start your time. We're ready to go? Go ahead, Jean, as soon as the time starts.
Very good. I am definitely for this. If I've read things correctly, they may be able to hire more council aides and part-time council aides. I believe this is necessary because even tonight, if you look at it, we have 34 resolutions, 6 first readings, and 8 second readings. The amount of documents that need to be scoured and reviewed for the council members as well as their aides is really outstanding. I think Mr. Gilmore stated there was 1,600 pages of documents that had to be read. This is unacceptable. So I do wholly support that the council people can hire more aides. However, whether it's part-time, I don't remember the exact wording of it. but it's very important. And in that note, I would ask that we reduce the amount of resolutions and ordinances for every single council meeting, because it's absurd. Thank you.
Gene, it's not only that, it's all the telephone calls all day long, parking problems, this problem and that problem.
Motion.
Wait. This is still a public hearing on City Ordinance 22-007. Any member of the public still wishing to be heard, please come up to the podium and state your name for the record.
Motion.
Hearing none, we have a motion to close the public hearing on Ordinance 22-007 by Councilperson Rivera. May I have a second? I think that second was made by Councilperson Prinzary. She got in there a lot earlier. On the motion to close the public hearing on City Ordinance 22-007, Councilperson Ridley.
Aye.
Councilperson Prinzary.
Aye.
Councilperson Baggiano.
Aye.
Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman.
Aye.
Motion carries 9-0 to close the public hearing on City Ordinance 22-007. Council members, as spoken about at the caucus, I believe we need a motion to amend the ordinance as discussed at the caucus. The amendments are as follows. Well, before I do that, do we have a motion?
Motion.
Motion made by Councilperson Saleh. May I have a second?
Second.
Second by Councilperson Solomon. To amend City Ordinance 22-007 as follows. God bless. If you call your attention to page 4, if that's page 4 on your agenda or on your ordinance, section 53-7, Workplace Regulations, subsection C, where it's striked out where the council aides shall work 35 to 40 hours. It's now going to say more than 25 hours per week, or as full-time employees are identified in the City of Jersey City's policy and procedures.
Mr. Clerk, sorry about that. I spotted a typographical error that should say, or as full-time employees as defined in the City of Jersey City policies and procedures. I apologize for that.
As defined, okay. Okay, no problem. So as defined in the City of Jersey City's policies and procedures, I'll have that corrected. And then where it's listing the salaries of the full-time council aides, stricken out is 50 to 85. It's now going to be from 40,000 to 75,000. And then the last amendment is on the last page, which is an amendment of, apologize. Oh, yeah, look at my finger. What's the, section 53-11, very last paragraph, it says, each council member shall set the salaries of their own prospective council aides within the prescribed salary range set forth herein. So before we vote on this amendment, council members, Corporation Council, can you confirm that these amendments are not substantial and would require re-advertisement by the municipal clerk?
Mr. Clerk, the amendments that were placed on the record are not substantial changes.
Thank you very much. Council members, we had a motion made by Councilperson Saleh and seconded by Councilperson Solomon to amend City Ordinance 22-007. As I read into the record, Councilperson Ridley.
Aye.
Councilperson Prinzary.
Aye.
Councilperson Baggiano.
Aye.
Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
About that. Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman.
Aye.
Motion carries 9-0 to amend City Ordinance 22-007, as read into the record. For final consideration and adoption of City Ordinance 22-007 as amended, Councilperson Ridley.
I just want to say thank you to Councilman Solomon and Council President for working on this. We all know that we can definitely use additional help, and this will be very helpful to the council. We do have a large workload. We do have a lot of residents under each one of us. We know this is a growing city, and this will definitely assist us with being more responsive to our residents. So with that, I vote aye.
Councilperson Prinzary.
Thank you to Council President and Councilman Solomon for moving this forward. I think it's really important that people are paid what they're worth, and we all know that our aides do a lion's share of the work that we do, not only for our office, but and more specifically for the residents of this city, to make sure that questions are answered in a timely fashion, to make sure that issues are addressed. So with that, I happily vote aye.
Councilperson Baggiano.
Aye.
Councilperson Saleh.
I want to thank Councilman James Solomon and Council President Joyce Waterman for putting this forward. This is going to take a load off our backs to help service as many residents as possible. As Councilwoman Denise Ridley just said, you know, we are a growing city and we need the help, and there's a lot of residents asking for it, so thank you so much.
Councilperson Solomon.
Thank you to the council president on this, and then thank you to all the colleagues for working together collaboratively to move it forward. And just as a, a concrete example of how this can help with the issue with the parklets that was raised, not having 2 full-time staff members. If had a second, you could have had someone proactively reaching out to the restaurants, talking to them. But there's real limits on what we can do with either 1 full-time or 2 part-time staff members. So I think this will really help all of us. And as I said, in some ways, it should increase the expectations for us of what we can deliver for our residents. And so with that, I vote aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Great job by both my council colleagues, Council President and Councilman Solomon. This is going to be great for our aides. They work hard. They definitely deserve it. I happily vote aye.
And Council President Waterman.
I want to thank Councilman Solomon for just working together on this. So often people don't see how we really work together on issues. And this is an issue that we know that is deserving. Our aides are really like 24/7. And the amount of information that they have to gather for us, and not only that, read just as much as we do. So with that, and I do believe people should get paid their worth. And with that in mind, I do vote aye happily.
Okay, City Ordinance 22-007, as amended, has been adopted unanimously 9-0. On to our next second reading ordinance, which is item 4.5, City Ordinance 22-008, an ordinance supplementing Chapter 332, Vehicles and Traffic, Article 8, Permit Parking, amending Section 332-66, on-street resident-only permit parking zones to extend Zone 11 on various streets. This is a public hearing on this ordinance. Any member of the public wishing to be heard, please come up to the podium and state your name for the record.
Motion.
I have a motion to close the public hearing on City Ordinance 22-008 by Councilperson Rivera. May I have a second? I didn't hear.
Second.
Second by Councilperson Saleh. On the motion to close the public hearing on City Ordinance 22-008, Councilperson Ridley.
Aye.
Councilperson Prinzary.
Aye.
Councilperson Baggiano.
Aye.
Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman.
Aye.
Motion carries 9-0 to close the public hearing on City Ordinance 22-008. For final consideration and adoption of City Ordinance 22-008, Councilperson Ridley.
Aye.
Councilperson Prinzary.
I'd like to thank Mike McKeon and Gloria Manderville for working with their neighbors to get the requisite number of signatures to move these streets into the St. Peter zone parking. And I'd also like to thank Jen Cato for giving this timely attention and due diligence. With that, I vote aye.
Councilperson Baggiano.
Aye.
Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman.
Aye.
City Ordinance 22-008 is adopted unanimously, 9-0. On to our next second reading ordinance, item 4.6, City Ordinance 22-009, an ordinance supplementing Chapter 332, Vehicles and Traffic, Article 9, Parking for the Disabled of the Jersey City Code, designating reserved parking space at various locations throughout the city. This is a public hearing on this ordinance. Any member of the public wishing to be heard, please come up to the podium and state your name for the record.
Motion.
Motion to close the public hearing on City Ordinance 22-009 was made by Councilperson Rivera. May I have a second?
Second.
Second by Councilperson Baggiano. On the motion to close the public hearing on City Ordinance 22-009, Councilperson Ridley.
Aye.
Councilperson Prinzary.
Aye.
Councilperson Baggiano.
Aye.
Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman.
Aye.
Motion carries 9-0 to close the public hearing on City Ordinance 22-009. For final consideration and adoption of City Ordinance 22-009, Councilperson Ridley.
Aye.
Councilperson Prinzary.
Aye.
Councilperson Baggiano.
Aye.
Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman.
Aye.
City Ordinance 22-009 is adopted unanimously, 9-0. On to our next second reading ordinance, item 4.7, City Ordinance 22-010, an ordinance adopting amendments to the Morris Canal Redevelopment Plan regarding the creation of the Berry Lane Park North Zone, also known as 417 Communipaw Avenue, Block 18901, lots 23 and 29, and remand per September 23rd, 2021 court order. This is a public hearing on this ordinance. Any member of the public wishing to be heard? Okay.
Good.
You can state your name for the record, please.
My name is Renee Steinhagen. I'm with New Jersey Appleseed Public Interest Law Center, and as of a week ago, I can take my mask off?
No. We just need you to state your name for the record and just bring the mic a little closer. And could you spell it first, please?
Okay, I'm going to take off too. RENEE STEINHAGEN.
Thank you very much. Is the time started?
It says 3 minutes.
Okay.
I'll hurry up.
You're going in right now.
Good evening, Councilman Waterman and the City Council. My name is Renee Steinhagen. I'm the Executive Director of New Jersey Appleseed Public Interest Law Center. We were a participant in the litigation challenging the inclusionary zoning ordinance with Fair Share, and I am co-counsel in the Morris Canal case. This evening, I just want to talk about two related issues, the issues of affordability and its relationship to the trade-off that went on between community benefits in these amendments. These amendments are pervaded with so-called community benefits that were negotiated by the former city councilman and the JCRA. They were not negotiated by the stakeholders in the community, and they were supposed to have, who were supposed to have an active decision-making in this redevelopment plan due to the fact that this was informed by the EPA's documents. Nevertheless, what I wanted to say is that the proposed amendments, notwithstanding their failure to include all the stakeholders in the decision-making process, these amendments were the product of an unlawful paradigm where there's a trading off of so-called community benefits for affordability. Here, the amendments only propose 5% affordable housing of workforce housing. That was the paradigm that was in effect under the ordinance that the planning department had proposed in 2018 and was not initiated was never adopted by this council. Nonetheless, the trade-off of community benefits for affordability, which is clearly in these amendments, was found unlawful by the court. And so therefore, from our perspective, we are dealing with plan amendments tonight. We are not talking about a plan application, so the time of decision-making, the time of application is in effect. What we're really saying is that the judge in the matter of the Morris Canal case invalidated the ordinance that you had previously passed, had remanded it for you to now reconsider based on the planning reports that the planning board was ordered to do. And so tonight, these amendments are judged by the current master plan and its implementing ordinance, which is the new inclusionary zoning ordinance. So despite other inconsistencies that other people are going to talk about tonight, I just want to reiterate that tonight, these amendments are inconsistent with the inclusionary zoning ordinance. They only require 5% workforce housing and do not require 10% affordability. Thank you.
Thank you very much. This is still a public hearing on City Ordinance 22-010. Any member of the public wishing to be heard, please come forth and state your name for the record, please.
Jerome Choice.
Okay, Jerome, your time is going to start right now.
Yes, I'm calling about these amendments that are for the redevelopment plan for this development. This is not what the community wants as far as building in our area. These amendments were not brought to our community in a proper way, and these amendments violates a lot of the things that we have in our redevelopment plan for Morris Canal. Thank you.
Thank you very much. This is still a public hearing on City Ordinance 22-010. Any member? Okay, I see June Jones.
Good evening.
Good evening.
Go ahead, June.
I'm here tonight to talk about Ordinance 22-101. And I'd like to ask the council to consider tabling this ordinance. On Tuesday, just this past Tuesday, we met with the developer, finally. And I want to thank you, Councilman Gilmore and Councilwoman Ridley, for attending that meeting. I thought it was quite productive. We found, some of the people that participated were community architects that saw another vision in how we could do this project, work with the developer, and not have such an offensive height in the neighborhood. The height is really offensive, 17 stories towering over 2- and 3-story buildings that exist there is just not right. The community doesn't want it. It changes the whole face and charm of our neighborhood. And there's an alternative way of having that done. So the developer has committed to working with the community. However, he has not committed to lessening the height. He didn't say no, so I'm holding out hope, but he did commit to further meetings, and I'm hoping out of those meetings we would be able to work something out so that we all will be able to live with what is built there. We are amendable and agreeable to all of the other things, such as the basketball court, the recreation center. As a matter of fact, the seniors would like something inclusive for them, so we would like to be creative and put something out there that would service people in the area for all ages. So with that, I want you to know that it seems to be a work in progress, and because of those meetings that I'm looking forward to us having, I ask that you consider tabling this until we get to a point that we could have an agreement to what's built on that site. And Renee Steinhagen with New Jersey Appleseed is correct. We've been talking a lot about the project. The project is only conceptual. We haven't, and as a matter of fact, when it was remanded, the amendment itself, it was about the amendment, not the project. We haven't even discussed the project. We haven't even seen any full renderings. So when the judge looked at this, it was the amendment, not the project. And that's all we're talking about. Thank you.
Thank you very much. This is still a public hearing on City Ordinance 22-010, and I seen Jean Daly.
Yes.
Okay, Jean?
Oh, okay, here we go. Yes, my name is Jean Daly. I did attend the virtual meeting with both the contractor and various parties. I do believe it was successful in many ways, unsuccessful in different ways. But the one thing that was pointed out by Renee is that as far as the master plan, the current master plan, that tower is not permitted in that particular structure and configuration. So it is not permitted under the master plan. This is the issue, especially with these amendments. Firstly, the 17 floors is completely out of scale with the surrounding area. It's going to cast shadows. They say it's not going to cast shadows in the park, but it casts shadows on everybody else. What I find unusual about this is that this seems to be something that was construed or constructed by former Councilman Robinson, and it appears that it was different hands were at the table, perhaps exchanging things in order to get what they wanted personally. And it seems to me that what they wanted personally did not comply with the law, especially the inclusionary housing. You know desperately we need low-income, moderate income, and not just workforce housing because we can't afford it. People here cannot afford it, and I know. What concerns me now is that if you're going to make this amendment, you are basically creating a loophole for developers. Wasn't it the point that we're supposed to have this inclusionary housing so we have the low, moderate, middle income and workforce housing? Wasn't that the plan? These amendments do not comport with the master plan. That tower does not comport with the master plan. And we are thereby carving out a special loophole for this special developer who came up with some deal with a prior council person because there were different people involved who wanted a piece of the action. They were going to gain something. The community was left out of the process, and now for the first time the community is, because of a judge, is permitted into this process. So from my point of view, we cannot have these types of exceptions. We cannot have a towering 17-story building in that area. It's completely out of scale. And additionally, we cannot create these loopholes. It's just plain downright illegal. And the affordability is very important to us, and I know they've been sitting on this project for 3 years, but maybe if we had a different council person back then, things would have gone more smoothly and the community would have been discussed and community would have been involved, and that's the kind of stakeholders we need, not a corrupt council person. Thank you.
This is still a public hearing on City Ordinance 22-010. Any member of the public wishing to be heard?
Good evening. My name is Ronald Shalgian. I'm with the firm of Schumann Hanlon, and I represent the proposed designated developer of this site. And I wanted to clear up some of the misconceptions that this board may have, this council may have this evening. The first misconception is we are here because a judge directed the planning board to conduct further hearings and determine the basis for their decision to refer these amendments to the council for their approval. We're here on a very limited basis. That's what you're voting on tonight. We're not voting on a project. We're voting on what the judge has ordered to be done. The planning board held an exhaustive hearing. Everyone had an opportunity to be heard. They were heard. The planning board rendered a report. The report was turned over to the council. Nothing in the amendments that are before you tonight are different from the amendments which were passed previously by this council. And I wanted to make that clear. And I think your focus tonight and your vote is very narrow. You're obligated by the court to make a determination and to determine that you're going to accept the planning board's recommendation to amend the plan because they have now supplemented the record with facts that the court required. The other point I wanted to make is that there's some misconception about community input. Now, this has been going on for almost 3 years. In early 2020, my client discussed the project with community groups in Ward F, and in March of 2020, Mr. Mont attended a Morris Canal stakeholders meeting and presented the project to approximately 50 attendees, including Ms. Jones.
Ron, can you make sure that your mic is down by you?
Thank you. Sorry. In March and April, the Morris Canal CDC provided feedback. My client used the feedback to modify the plans. In May of 2020, Ms. Jones apparently refused to call another stakeholder meeting despite our request to do that, and Mr. Mont and the Planning Division had their own virtual neighborhood meeting for the Ward F community. That was in June of 2020. On June 10th of 2020, June sends a letter to Mayor Fulop objecting to the development.
Thanks, Ron.
And the community input continued up until yesterday when we attended the virtual meeting. But the point, I think, is that you have
Thanks,
a
Ron.
narrow focus
Thank you.
that I
Thank
asked
you,
to
sir.
act on.
Thank you so much.
Thank you.
Mike ain't on. Thank you.
This is still a public hearing on City Ordinance 22-010. Any member of the public still wishing to be heard, please come up to the podium and state your name for the record.
Hi, my name is Gary Spingarn.
Can you spell your name for us, please?
No problem. S-P-I-N, like spin a ball, and G-A-R-N, N as in Nancy.
Okay, thank you very much.
I'd just like to address a, I guess, broader, more general point here. Of course, this development near Berry Lane Park has been all over the media, a huge part of public discourse for absolutely years now, and I just want to get something on the public record. I find it extremely, I guess, funny that when it comes to a developer providing things for the community, say a basketball court or community rec centers, the thing that they are least willing to give is the affordable housing itself. And that is entirely by design. Everything that they are doing and want to do is predicated on that they need to commodify on what people need to survive. Providing affordable housing is against their business interests. And it's funny how it always boils down to, well, it goes from half of it, 10%, 5%, and people just watch the numbers go down. And it absolutely makes me sick. We are in an affordable housing crisis in the city, and it absolutely pains me to hear this 5% number being thrown out. We can absolutely do better than a basketball court. We need to stand up to what the business interests want. We keep feeding into the disease that is causing so many problems throughout our city. I absolutely hope that we can do better in the future. Thank you.
This is still a public hearing on City Ordinance 22-010. Any member of the public wishing to be heard, please come up to the podium and state your name for the record.
Peter, can I ask you a few questions, Peter?
Wait,
Motion to close.
you have to wait.
Okay. We have a motion to close the public hearing on City Ordinance 22-010 made by Councilperson Rivera. May I have a second? I believe that second was made by Councilperson Prinzary. On the motion to close the public hearing on City Ordinance 22-010, Councilperson Ridley. Councilperson Prinzary.
Aye.
Councilperson Baggiano.
Aye.
Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
and Council President Waterman.
Aye.
Motion carries 9-0 to close the public hearing on City Ordinance 22-010.
Yes, Peter, just a few questions so we can have exact clarity. What exactly are we voting on today?
So once again, to clarify, this is a very limited matter that is put before the council. On September 23rd, we received a court order from Superior Court Judge Delia remanding the matter of the amendments that had been adopted by the council in December of 2020 to place on the record the reasons that, the explanation and the findings of the planning board as to how the amendment was consistent or inconsistent with the master plan. In December of this year, the planning board held an extensive hearing and proceeded to place on the record its precise findings as to how the proposed amendments do comport with the master plan. The court was bound to consider a standard of arbitrary and capricious. What did the planning board make an arbitrary and capricious finding either in favor or against? And in this case, the planning board found that yes, this is consistent with the master plan for these delineated reasons. This was presented to the council in the form of this ordinance for review in first reading last month. And now the adoption of those findings to incorporate within the amendment are before the council tonight.
So within those findings, so we vote today to move forward, this zone would essentially be allowed to have a 17-story dwelling, correct?
Apologies. Provided that I have not reviewed the recommendations and the exact meets and bounds of the amendments. However, what is recommended within those amendments would be within the meets and bounds, again, of the potential project, yes.
So I guess my next question is, if we vote to table it, will we be under any, I guess, any obligation from the court or anything with regards to how long it can be tabled or if it can be tabled?
As a legal matter, I'm not familiar. We did not receive a specific deadline as to this. However, I believe
That's basically what I want. Okay. So my issues with this essentially is that the 17 stories, and many of the constituents in the community are saying that it's going to set precedents for this area. Now, I've met with Lou several times. We've been going over this for a long time, and I'm not going to say he's going to do anything ill or unethical or whatever. But the problem with this proposal and the problem with voting on it as is that it will allow other individuals. There's nothing stopping a developer for buying up the whole row of single-family houses and putting up a 17-story there. There's nothing stopping Lou from selling the plans. There's nothing stopping, there's nothing in the cards that say something is not going to happen to him and he can't bring to fruition what his idea is. And he have met with the community. I agree with him on that matter. However, the community have said overwhelmingly, time and time again, that 17 stories is just too big. And to give a comparison, we're building a public safety building on the corridor of MLK. It's 12 stories, I think. That thing is huge. So while his disposition is that 17 stories is not going to really be without the scope of the community, I think it drastically is. So at this juncture, I have been in extensive contact, and He stated that he's willing to work with the community and listen with the community, so I want to take him on face value. So at this juncture, I'm looking to table this to engage in extensive conversation because we don't want to say, let's engage in negotiations or let's engage in what's going to go up when the threshold is already set at 17. I think it sends a bad message to the community. And again, the community overwhelmingly, every single meeting I've attended, overwhelmingly have said that 17 stories is astronomical. Granted, we want to see something there. He said he's been in with this project for 2 years. I've lived there my whole life. I want to see something there. I don't think anyone is opposing to to any of the community benefits and givebacks. I just think that we have to really, really have the community dialogue, and at some point, we have to make sure that the community voice is being considered and not just heard. So at this juncture, I am going to request that we table it. So, and then my next question to Peter would essentially be, would there be a required or permitted time in which this have to be brought back?
No time.
No time. No time?
No time, and that's what he said the first time, is no time limit. He didn't say it.
Council, while Peter's reviewing that, before the motion is drawn for a table, I just want to remind the council that this is the technicality from the court brought back to the planning board. And I do hear the councilman's concerns about height and future projects, but those would have site approvals moving forward through the planning board and then with consideration of the council and the community. So I just want to reemphasize that we're working on what the court asked the planning board to go back and specify tying into the redevelopment planning and the master plan.
This is to create a new Berry Lane Park North Zone, correct? This is what, it's not a site plan. It's just to carve out that corner and say, you know, basically the planning board did everything else, and this is the judge coming back and saying, hey, you need to make a zone for this, and it's, is that,
The remand was for the limited purpose of the planning board stating for the record how it is consistent with the city's master plan, which they've done and which they transmitted to the council last month. So it is those findings that, we are, again, bound by the court to consider the amendments as they were adopted in 2020, but with the findings as to their consistency with the master plan as provided to the council.
Peter, I have a couple questions that I want to ask. I know someone mentioned while they were speaking about the IZO. This project wouldn't apply to that because it was started or approved beforehand, before we voted on the IZO. Is that correct or not correct?
Yes, the current IZO was adopted by the council in December of 2021. The amendments that we are addressing tonight were adopted by the council in December of 2020, which does predate the IZO. So the terms, the meets, the bounds, everything else with regard to this plan were under the prior scheme.
you can't retroactively have them enforce the new IZO ordinance, is that correct?
No, not under these circumstances.
And the amendments or the formation of this zone, does it apply to areas outside of this particular development site, or is the Berry Lane North Zone just this site?
It is the Berry Lane Park North Zone within the Morris Canal redevelopment plan. It does not extend outside.
So this wouldn't allow for a slippery slope?
What do you mean by slippery slope?
Like, it's just carving out that corner from what I see in the map. And making it mesh with the master plan.
Yeah, and I think, the planning board, again, issued its findings as to how it's consistent with the master plan, present to the council for their adoption and incorporation into the amendments which are already in the code.
And it looks like the rest of the area is an industrial zone, correct?
Yes, it is.
Thank you.
So your assessment, Peter, is that this, if approved, this would not open a gate for other developments to go at the same height within the area?
Not outside of the redevelopment zone as described here. It would only apply to this.
Yeah, see, that's why this is it's just so problematic. So that's why, I mean, like I said, the community have spoke up extensively with regards to this. And the developer, in his own words, is willing to work with the community. He wants to see how this can work. So I'm urging my colleagues, I'm requesting that we table this to make sure we're really putting the best product on this site. And I understand what the developer issue is. I understand what the BA is saying. I understand what the lawyer is saying. However, the bottom line is, if we vote tonight, it would allow a 17-story dwelling. Am I correct? Yes or no in that matter?
Council, the item that you're voting on tonight is just clarification for the redevelopment plan and the master plan. This project was pre-approved by the former council that left office in December 31st, and no changes have been made to that particular project. The community benefits are still existent. The level of affordability is still exists. This is simply going back to the planning board to specify that it meets the requirements of the redevelopment and the master plan. There's no changes, and we have not got any information from any developers that there will be any changes on the parcel.
So my question again is, if we vote tonight, would this allow a 17-story dwelling to reside within that zone? Yes or no?
Again, what the council is voting on tonight is solely the findings of the planning board with regard to its consistency with the master plan. What has already been adopted by the council are the amendments which are already incorporated, which includes, yes, that 17-story, that potential 17-story structure.
Thank you.
Okay, council.
So
You can bring it to a vote.
Okay, so,
I want
If you want to.
I want to make a motion
Right,
to
put it to the
table
vote.
this.
That's it.
yep. So I got a motion to table City Ordinance 22-010 after the close of the public hearing made by Councilperson Gilmore. May I have a second?
Second.
Second by Councilperson Solomon. On the motion to table City Ordinance 22-010 after the close of the public hearing, Councilperson Ridley.
So I guess I'm going to speak very plainly, because sooner or later this might get dropped into my lap with the redistricting. So I think that I had a good conversation with Councilman Gilmore. I think the meeting yesterday went very well. I think that we differ on what we think that this vote is tonight, based on what Peter said. And what I've read is that we're not, we've already accepted those amendments, and we are fulfilling court requirements tonight. But I think what we don't differ on is the point that the community needs to be heard. Every time there's a new building that goes up in Ward A, I have a community meeting. The developer is there, they present the plans, and I know that they've said they've had these meetings, but until that you're going before the planning board with site plan approval, they don't really know what's set in stone. The residents aren't sure yet, and they want to have those conversations. I think on the call yesterday, the developer and his attorney did agree to have those conversations. That meeting was recorded. I think that I don't know if the building will ever get down to 5, 6 stories, but I think there needs to be a conversation with the community about what they consider community givebacks, because that might be different from what planning considers. And I think that there is wiggle room here. What I'm going to ask and the commitment that I'm going to make is that we go back to the table, just like we said yesterday, with the community and the stakeholders to have those conversations about possibly increasing affordability. And I don't know how true it is, but I know that there was an alternate plan that had more affordability. So we can discuss that offline. And also maybe spreading the building out, because the units don't seem to be an issue, it seems to be the height. So I'm making that commitment to be at those meetings, and if I am the council person at that time, to host those meetings and make sure that happens, and to also find out what those community benefits are that are important to those residents and make sure that we're incorporating those, and maybe some of the ones that aren't important, we take out. When we are negotiating these developments, usually the residents get some of what they want, the developer gets some of what they want. But if nobody is losing anything, then it's not a compromise. So both sides are gonna have to give a little. But we're asking Mr. Mons, his team, to please make sure that you are including the community and that you are hearing what their concerns are. But since I do agree with Peter that that's not necessarily what we're voting on tonight, and we still have that opportunity before you go for site plan approval, and planning still needs to vote on this project, that we have those meetings before then, and I make a commitment to make sure that that happens and to work with Councilman Gilmore on that. So with that, I'm not going to vote to table, but you have my commitment on all of the above.
Councilperson Prinzary.
Aye.
The table.
Councilperson Baggiano.
I see what happened in the area of High Street, Perrine Street, Washburn Street, Baldwin Avenue, and the whole of Ward C with all these big buildings knocking down 1- and 2-family homes, destroying communities. And I think once you let one in there, it's the start of the destruction of this whole area. So I vote yes, table.
Councilperson Saleh.
Considering that this isn't a site plan approval and that this is a narrow question that we're here to answer, and that both Councilwoman Denise Ridley and Councilman Gilmore and the community and the developer are saying that they're going to work in good faith, I'm going to vote no to table.
Councilperson Solomon.
I'm going to vote yes to table, and just want to add 2 points. I think first, even within the narrow scope that the Corporation Council has defined, we as a council can disagree that this development is in concert with the master plan. Second, I think there's legal disagreement about whether the IZO applies. That may be dealt with in the courts outside of us here. But then last, there's no harm in tabling. If we pass this now, then legal requirements are set, and while the developer can come back to the community, there's no guarantee he can do so he'll do so in good faith. I'm not saying he won't, but he has his RDP approvals, and he can go directly to the planning board for site approval, and there's only limited grounds under which the planning board at that point would reject his proposal. So I think in deference to the new councilman in Ward F, that we should table this and allow for more community conversation and collaboration, and if it does get brought back before us, having it on the table agenda, it could come back in 2 weeks, 1 month, 2 months. I don't see a harm in tabling. So I vote yes to table.
Councilperson Gilmore.
Yes, the table.
Councilperson DeGise.
Yes.
Councilperson Rivera.
No to table.
And Council President Waterman.
No to table.
Motion to table City Ordinance 22-010 after close of the public hearing is approved 5-4, with Council members Ridley, Saleh, Rivera, and Council President Waterman voting no. On to our last second reading ordinance, item 4.8. City Ordinance 22-011, an ordinance amending Chapter 304, Article 9, Section 42 to reflect that the arts and culture Trust fund annual levy shall not exceed 2 cents per $100 of total municipal assessed real property. This is a public hearing on this ordinance. Any member of the public wishing to be heard? No one has come up to the podium. May I have a motion to close the public hearing on City Ordinance 22-011? Motion made by Councilperson Rivera. May I have a second?
Second.
Second by Councilperson Prinzary. On the motion to close the public hearing on City Ordinance 22-011, Councilperson Ridley.
Aye.
Councilperson Prinzary.
Aye.
Councilperson Baggiano.
Aye.
Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise. Aye. Councilperson Rivera.
Aye.
And Council President Waterman.
Aye.
Motion carries 9-0 to close the public hearing on City Ordinance 22-011. For final consideration and adoption of City Ordinance 22-011, Councilperson Ridley.
Aye.
Councilperson Prinzary.
Aye.
Councilperson Baggiano. Aye. Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman.
Aye.
City Ordinance 22-011 is adopted unanimously, 9-0. Okay, on to our public speaking portion of the meeting. I will call your name, and as I call your name, you will have 3 minutes to speak. So we're going to start with our first speaker listed, 5.1, Alex Stein. Are you here, Alex? Alex, not here. 5.2, Eve Taylor. Eve, not here. Speaker 5.3, Tayana Thompson. Tayana Thompson. Okay, next speaker, Jean Daly. Okay, Jean.
All right, hit the button. Thank you for that. Sorry, I'm so nervous now. I was going over a bunch of the resolutions, and yet again, I find some oddities that stick out. One of them is agenda number 10.12, about this eminent domain along, I think Ocean Avenue by the cemetery. The question I have, it states that it's going to be eminent domain without the powers of condemnation. But if you look at all the buildings, why are we going to eminent domain this? And you know darn well those buildings are going to have to be brought to the ground. So there seems to be some type of inconsistency in this ordinance itself, and I question why. Which department brought this forth to the council? We need to have a reason why we're going to do this, and my concern is that you have a developer who comes in and says, okay, I like property A, B, C, D, and E, and then I go to whoever I want to in the building department, what have you, JCRA, and acquire it. That is very, very disconcerting to me. Another confounding resolution is number 10.27, about Collins Engineering and Mazer Consultation. I understand the Corporation Council is the one who writes these ordinances, and I have to say, I totally disagree that a civil engineering is allowed for a no-compete contract when they're really not providing any type of special services. There is no indication or writing that states why this is a special service that is exempt from competition and competing contracts. Moreover, Jersey City has handed Colliers Engineering multiple contracts, all non-bid. There are dozens of engineering, civil consultancy firms throughout Jersey City and the New York area, obviously. So what is it? Why are we handing this one firm All these contracts are a no-bid situation. Moreover, the one that we're speaking about now is about putting arches on Indian Square. So this is a combined ordinance that says we're going to give them extra money for the Newark Avenue pedestrian plaza. We don't know if they even finished the work or not. And then we're just going to hire them for the Newark arches up by Indian Square. Every single thing with this company is very suspect because of these add-ons, these different add-ons here, different add-ons there, and how they will swoop in and take a park. All these contracts should be done individually and with a competitive clause. Thank you.
Okay. Our next speaker, 5.5, Gary Springarn.
First, I want to bring up a quick point about hybrid meetings. I know this has been brought up yet again. I just want to say that we had an overwhelming amount of public interest while we had virtual meetings, and let's face it, if I was immunocompromised, I wouldn't want to be in this room right now. And also, it's pretty hard to make it to City Hall 6 p.m. It's not a reality for everyone. We had heightened levels of public participation. We should like that, and the pandemic isn't over. So I hope that the council can pursue this. Second point, I'm glad to see that the ordinance 22-014 has been withdrawn. It's going to go on a little bit of a tirade, but I just want to say that I'm a car guy. I have to pay for my parking, and that's the way it should be. Parklets do a lot more for our businesses, and they serve the public good. The fees that were listed, I think, defied our values. So definitely looking forward to the edits that are going to come. Very excited about that. Finally, and this is the bigger point, I wish to address some information that I came across yesterday outside this very building. It pains me that the city is about to do business with a couple of entities that have a laundry list of transgressions, namely Iron State Development and Planned Companies. Transgressions such as, but definitely not limited to, discrimination, safety violations, defrauding and endangering residents, union busting, retaliation, and wage theft. The list goes on. This is a council and the executive administration, I recall, claim to be behind SEIU 32BJ, and that is why I am here. I want to echo these concerns and stand in solidarity. I'm speaking from a little bit of personal experience. Planned companies do very little to earn our trust and have done near everything to violate it. Such scandals during the pandemic are an absolute testament to that. I just ask this council to please listen to workers and stand behind them. Thank you.
Thank you very much. Our next speaker, Renee Steinhagen.
Good evening again. I'm new to this proceeding, and I just wanted to reiterate and support Councilman Solomon's position. I just want you to understand that the litigants in the Morris Canal case take a different view than Mr. Baker as to what the judge did. In fact, the reality is the judge found that your ordinance was arbitrary and capricious because there was nothing in the record from the planning board properly. So the judge remanded it to the planning board to make its report to you, to determine whether it was consistent or inconsistent. The planning board made a finding of consistency. That finding of consistency is not something you have to accept. We, in some position, feel that the plan amendments are inconsistent with the master plan. You are entitled as the city council to pass amendments that are inconsistent with the master plan. But if you do so, you have to state your reasons why you're doing so. You have to provide a basis for why you're making amendments that are inconsistent with the master plan. Now, if Mr. Baker's position was correct, there would be no reason for you to have introduced the ordinance again and have a second reading. You are now adopting the ordinance based on the planning board's recommendation of consistency, and you have to engage in that dialogue with the planning board. Some of us in the audience, believe that it is inconsistent, and we have given you two basic reasons. We feel it's inconsistent with the affordability goals as now enforced by the ordinance, and we think it's inconsistent with the height and the neighborhood appropriateness. We do not believe it is inconsistent because of density. People are complaining not about the amount of units, they're complaining about the height of the units. I gave you another reason why it was inconsistent. I told you it was based on a paradigm of trading affordability with community benefits. That paradigm was found unlawful by another superior court, and that's why you passed a new inclusionary zoning ordinance that no longer trades affordability with housing, okay? I mean with community benefits. The city, the planning department is entitled to ask developers to do community benefits as part of a redevelopment plan. What is unlawful is the trade-off between affordability and community benefits. So I just wanted you to know, and I'm very happy that you have made a decision to table this, because if you had not tabled this and voted it, you would be faced again. We would be going to the court, and we would be arguing that these amendments are inconsistent.
Thank you.
Thank you, Renee.
Well, thank you very much.
Okay, our next speaker, June Jones.
Good evening again. Last thing I want to do, for us to do, is go back to court again, but that would be the plan. And I would encourage the council, the city council, to understand what exactly we're voting on when we talk about that 2201.
June, bring the mic up to you. Thank you.
I would encourage the council to understand exactly what we're voting on when we're talking about the remanding of the amendment going back to court. That is important. We don't want to be in court again. And I like to think that your vote was done with your full knowledge and understanding of what has happened. Before, I was out of commission for a little while suffering from COVID. And before I went out sick, I was talking to you about contractors getting these contracts throughout the city. Spinello was one of them. And I think I texted you guys on several occasions to talk about the sloppiness of the work that they were doing. They would come in our neighborhood and sometimes closing off streets unnecessarily. The businesses in our neighborhood have suffered tremendously. But more importantly, the dust that they would leave behind. Any contractor knows that they have to minimize the dust in the neighborhood. And I called and I called and I called. I left memos and emails for Mr. Haydes. And then finally it got to the point where I think I text the council people. But what I wanted to tell you that I didn't get a chance to tell you on a follow-up council meeting is that we had a young lady who had a severe asthma attack and died. She was only in her early 40s. And one of the complaints was the dust, as I brought to their attention. I won't mention her name, but I am forwarding a letter to you, the council, because when we talk about giving contracts to people, it should not just be habitual. It should be because they do a good job. And I would speak to these gentlemen almost on a daily basis, telling them about the man who had COPD, the little kids who suffered from asthma, and they would say yes, 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 but it would go in one ear and out the other. So I would like to be able to make a complaint and know that the complaint is being acted on. I would call the the residents' response as well. So there's documentation of all of these complaints, but no one should have to die because of sloppy work of the people who we contract. I'm out of time.
Thank you. Our next speaker, 5.8, Bradley Silvestri.
Good evening. My name is Bradley Silvestri. Thank you for the opportunity of speaking here today. I was born in Jersey City, and for the past 5 years, I worked as the overnight concierge at the South Independence Building at the shipyard in Hoboken. I work every day from 12 to 8. Since I work by myself, some of my duties include checking inventory, making sure everything is in order, and that no one does not belong. Excuse me. In addition, because I work alone in the building, I take my break at my desk. You may know that Hoboken-based Iron State Development Company is one of Jersey City's most prominent developers. The shipyard where I work is owned by Iron State Development Company, and they contract my employer, planned companies, to provide services in the shipyard building. Iron State consistently employs low roads contractors with a long history of wage theft and retaliating against unionizing workers. Proof of this is the default notice sent to them by the city due to the non-compliance to the city wage. Benefits and leave standards for building service workers on covered development projects receiving tax abatement. Make no mistake about us, the workers, we work hard, and we are proud of the work we do. But just as we work hard, we want the building owner to do the right thing by us. Fair wages and benefits. Today, we are asking you, before Iron State or its affiliates are granted any approvals, that we urge you, Iron State Development, to do the right thing by the workers. Thank you for your time.
Thank you very much. Our next speaker, 5.9, William Arquetta.
Hi, I'm going to be translating for the next two speakers, so I would just ask a little extra time to be able to get through everything. Thank you.
No.
Buenas noches, miembros del Consejo. Mi nombre es William Argueta. Al igual que mi compañero, estoy aquí con respecto a Iron State Development. Vine a los Estados Unidos desde Honduras hace 6 años. He estado trabajando en Columbus, en el 70 de Columbus, desde entonces. Trabajo en mantenimiento, manejando el reciclaje y el compactador de basura todos los días de 7 a.m. a 3:30 p.m. Vivo en New Jersey con mis hermanos y junto a ellos apoyamos económicamente a nuestras familias en Honduras. Las torres 70 y 90 Columbus son propiedad de Iron State Development Companies y Pine Pinch Properties. A los pobres de estos edificios se les pagaba mucho menos que los salarios exigidos por la ordenanza de la ciudad de Jersey City. Javier Amador, pobre de los edificios, fue despedido luego de quejarse de robo de salario y entregar una petición al codesarrollador del edificio, Iron State, sobre las condiciones laborales. También es importante que sepa que la ciudad de Jersey City encontró que en el desarrollo no cumplió con sus compromisos para la reducción de impuestos durante la investigación de la ciudad por robo de salarios. El desarrollador se negó a proporcionar registros de nónima, como lo exige la ley. Los propietarios de los edificios pueden deber a los Potters en 70 y 90 Columbus Drive cientos de miles de dólares en salarios atrasados. Entendemos la importancia del desarrollo, pero necesitamos un desarrollo responsable y, lo que es más importante, contratistas responsables. Por favor, antes de seguir adelante con cualquier aprobación para Iron State o sus afiliados, pídales que hagan lo correcto por parte del personal. Traigan de vuelta a Javier, paguen sus salarios justos y brinden beneficios y mejores condiciones de trabajo para todos. Gracias.
Okay, I'm going to be translating for William.
Sir, do you have that written down?
Yes.
It's me.
Yes.
We can make a photocopy of that and give that to the city council. It's up to the council president if she'll allow it, but if you have it written, I can have my deputy make photocopies for the entire council, so then we can have the next speaker come up.
Okay.
Just translating for one, right?
It's for both, and I was asking to translate for both. Am I able to do that?
Well, is it the same Is it
It's the same thing, I'm just
Okay,
translating in
just
English.
read one then. And you
Okay.
can read it to us. Just read one.
Good evening, members of the council. My name is William Arqueta, and like my coworker, I am here regarding the Iron State Development Companies. I came to the U.S. from Honduras 6 years ago. I have been working at 70 Columbus ever since. I work as a porter with the recycling and garbage compactor every day from 7 a.m. to 3:30 p.m. I live in New Jersey with my brothers, and together we financially support our family in Honduras. The Columbus Towers, 70 and 90 Columbus, are co-owned by Iron State Development Companies, the parent company of the redeveloper in question and Panapinto Properties. The porters in these buildings were paid far less than the wages required by the Jersey City Ordinance until recently. Javier Amador, a porter at the buildings, was fired after complaining about wage theft and delivering a petition to the building's co-developer, Iron State, regarding working conditions. It is also important that you know that Jersey City found the developer in default of its tax abatement during the city's investigation of wage theft. The developer refused to provide payroll records as required by law. The building owners may owe the porters in 70 and 90 Columbus hundreds of thousands of dollars in back wages. We understand the importance of development, but we need responsible development and, most importantly, responsible contractors. Please, before you move forward with any approvals for Iron State or its affiliates, please urge them to do the right thing by the staff, bring Javier back, pay fair wages, and provide benefits and better working conditions for all. Thank you.
Thank you.
Our next speaker, 5.10, Manuel Zayas.
Okay, Manuel's is a little different. Am I able to translate for him as well?
I thought it was the same. Is that
No,
the
it's a
same
little
one?
different.
Is that the same one?
No, it's a different.
Is that different? Okay.
It's
come on,
okay?
Come on. Thank you. I know. Come on. Everybody's upset. Come on. Go ahead.
Noche. Mi nombre es Manuel Salle. Trabajo en mantenimiento en 90 Columbo. Tengo 49 años y he vivido en Jersey City durante los últimos 15 años. Soy originario de Honduras. En 90 Columbos trabajo limpiando muchas áreas, así como el reciclaje y el compactador de basura. Creemos que cualquier compañía de desarrollo debe considerar las consecuencias de tener a un contratista irresponsable antes de comenzar cualquier proyecto. State Development Company no hace eso y nosotros, los trabajadores, estamos a merced de las empresas que no solo nos pagan salarios bajos, sino que también nos silencian con tácticas de represalia cuando planteamos las cuestiones de mejores condiciones de trabajo. Nuestro compañero de trabajo, Javier Amador, fue despedido al día siguiente de hacer esto. Desde entonces hemos enviado peticiones, hemos intentado hablar con el desarrollador y hemos sido ignorados como le confiaría algún desarrollo a dicho ¿cómo le confiarían algún desarrollo a dicha empresa? Mientras ustedes trabajan para hacer avances, para avanzar a la ciudad, es su deber proteger a todos los que trabajan y viven aquí. Les pido que antes de dar algún proyecto a Iron State o sus afiliados hagan lo correcto por los trabajadores, los residentes y la ciudad en general. Gracias.
Good evening. My name is Manuel Zayas. I am a porter at 90 Columbus. I am 49 years old, and I have lived in Jersey City for the past 15 years. I am originally from Honduras. At 90 Columbus, I work cleaning many areas as well as the recycling and garbage compactor. We believe any development company should consider the effects of hiring an irresponsible contractor before they begin any project. Iron State Development Company does not do that. And we, the workers, are at the mercy of companies who not only pay us low wages, but also silence us with retaliation tactics when we raise the question of better working conditions. Our coworker, Javier Amador, was fired from one day to the next after he did just that. Since then, we have delivered petitions, we've tried talking to the developer, and we have been ignored time and time again. How would you trust any development to such a company? While doing your best to advance the city, it is your duty to protect all who work and live here. I call on you to make sure Iron State and their affiliates do right by the workers, the residents, and the city as a whole. Thank you.
Thank you.
Next speaker, 5.11, Ryan Williams.
Hi, Council. Am I good?
Yep. Go ahead, Ryan.
Okay. I'm a trustee of Bike JC, and I wanted to talk about some things I hope we can work together on in the next 4 years. My main message is that we will all be better off by helping people move around Jersey City on 2 wheels, meaning using bikes, e-bikes, and scooters for transportation. Obviously, it's not something everyone is going to do for every trip, but if there was one single safe way to get most places in Jersey City, a meaningful percentage of people would do it, and that is also the best thing we can do to improve our traffic and parking problems and prevent them from continuing to get worse as the city continues to grow. It sounds counterintuitive, but I promise that the policies that Bike JC is advocating for here will improve conditions for drivers as well. We have a lot of data from other cities doing this during the pandemic. There's really no mystery to it. It just requires having one safe way to get to major destinations like parks, grocery stores, schools, and transit hubs, where right now there are 0. There's 0 ways for me to get most places in Jersey City on my e-bike. It's pedal assist. It tops out at 20 miles an hour. It's an amazing way to get around, but it requires sharing the road with drivers and cars that are much bigger, and the dynamics are just hard. I can do it. It's uncomfortable. Sometimes it's quite scary. My wife can't do it most of the time. So, by not having a single safe way to get most of these key places, most people just are banned from doing it, right? That results in people having to take cars for every single trip, and that contributes to traffic and parking problems that are, very severe, obviously. So, the planning board passed the Bike Master Plan in 2019. It shows how a few bike lanes around the city can give us a network that lets people have one safe way to get to most major destinations. So I'm hoping to follow up and work with each of you to figure out how we can make that happen. Thank you.
Thank you.
Ryan, how you doing? Ryan.
Hi. Yeah, what's up?
Ryan, I'd love to engage with you in conversation, so
Yeah.
maybe we can do a small crusade throughout the city so that we can walk through it, so that we can just talk about, I just want to engage in what are your thought process on the whole scope of things.
Yeah.
And I'd be open for suggestions, from you, and I hope that you're open to suggestions from me as well. Okay?
100%. Much appreciated.
My office will get in contact with you so that we can, try to, maybe some other council members might want to join us in a walk and talk throughout the city and engage in the conversation of bikes.
Cool. Yeah, that sounds great.
Okay, thank you.
Thank you.
Okay, our next speaker listed, 5.12, Jerome Choice. He left, okay. Next speaker, 5.13, James Lee. Go ahead,
Good
James.
evening, Council. James Lee, organizer with Safe Streets Jersey City. I live in Jersey City. I have a young daughter, and together we walk, drive, bike, take the train, bus throughout the city. I want to first just briefly thank Councilperson Solomon Gilmore for commemorating World Day of Remembrance with us last year, where we remembered those who died in preventable crashes in our city last year, as well as Councilperson Solomon's continued work on safe streets throughout the city. I also want to thank Councilperson Prince Aries for recently organizing a joint meeting with the county, law enforcement, and others on how we can make our streets safer on the west side and beyond. While we had a bad 2021 working together, I firmly believe that we can still reach our joint goal of Vision Zero by 2026. I want to comment briefly on parklets. I just want to weigh in and say that they've made our streets more calm and also, more importantly, more beautiful and more fun. And we absolutely should not have high fees that disincentivize their creation. If there's any feeling of unfairness and unexpected windfalls for landlords or businesses, I would recommend that the city look into a storefront rental income tax that would not inhibit small business from creating publicly beneficial parklets with high fees of thousands of dollars per year. Tonight, I just want to also bring to the council's attention the JFK Boulevard redesign project, which was started in 2015 and is now projected to be completed in 2026. While a county project, the segment from Pavonia to St. Paul's lies entirely within Jersey City's limits. Last week, the NJTPA presented their primary preferred alternative, and after all these years, the underwhelming plan can be summarized as a lot of sidewalk. There are a few major problems with this project. First, it does not include any discussions with New Jersey Transit on how we can enhance service for the many buses that run through the area. By their own admission, they counted buses as a single vehicle in their calculations, even though each one of them hold 1 or 2 dozen passengers. Second, this is already a disastrous project from when the primary goal is safety, by taking over a decade to complete. And it is not complete. I urge that we redouble our efforts with quick builds, safe bump outs, separated bike lanes, and right-sizing our city streets and turning speeds for the city. I also urge that the city work with and pressure the county to get improvements quickly with a quick build, and that includes bike lanes, that leaves further flexibility for provisions for bus rapid transit in the future. Last, I just want to share a statistic. Separated bike lanes result in 44% fewer deaths and 50% fewer serious injuries for all road users. Separated bike lanes make streets safer for all and improve the comfort for all of the citizens of the city. Thank you.
Thank you very much. Okay, council members, none on your printed agenda but signed up before the meeting started. We have speaker 5.14, Tori Onspatch. If I mispronounce your name, I'm sorry.
Good evening, council. My name is Tori Onspa, and I'm the chef owner of Hook JC Cafe Elise, and I'm also an operating partner at JSQ Lounge. First off, I'd like to thank whoever it was that went through the 3.5. I find it distasteful that it was put out 24 hours. I was given 24 hours notice for this, considering I self-manage 3 small businesses here, which would be greatly affected by this decision. But I'm used to pivoting and adjusting along with the pandemic. Mostly, I'm here this evening out of concern for a 50-plus year tradition that deeply affects my business and my partner's business, because I'm the operating partner there, at JSQ Lounge in Journal Square. It was brought to my attention that a city, well, not a city council member, excuse me, but a city worker happened to be having a beer with one of my regular patrons, who informed me that the St. Patrick's Day Parade's route was being moved this year. For me to find this out through word of mouth, grapevine, backroom, less than 40 days before the biggest day of my year, and kind of coinciding with the COVID shutdown, is devastating to my business. We turned that establishment around from someplace where there was a lot of drug activity, a lot of police presence, just a lot of no good stuff going on before we took it over. Through hard work and determination, we actually turned that one little square right there next to the Lowe's Theater, and we made it a little bit safer from some of the shenanigans that were going on, not only inside, but outside. Once again, this was just through sheer determination. So to find out that the city, through whatever kind of back channels, decided that they were going to pull this event for whatever reason, and I get it. I think it's just the timing, kind of like the other issue. It's the timing that's just really gross. It coincides with the COVID shutdown. That was actually going to be our 1-year anniversary, St. Patrick's Day, the year of the shutdown. We were excited to have a lot of new patrons come in and discover our beautifully renovated place, the great scratch kitchen, the great craft cocktails, all of our smiling, happy staff, and it was ripped away from us by nobody here's fault. So then to once again get excited and to have invested, my partners have invested over $250,000 in the past 10 months into this space in just payroll and rent and insurance and improvements, to then have the one day that we thought that we were going to be able to introduce a large number of people from Jersey City to our establishment so that maybe we could pull in some of this business from outside of downtown, is soul crushing. Soul crushing. And to not have any word of this anywhere is really disheartening. And I'm doing everything I can to fight for Jersey City, being a new resident and a business owner, and I'm just ashamed. That's all.
Thank you. Next speaker, 5.15, Brian Kolbacki. Brian? Did Brian leave? I think so. And the last speaker, 5.16, Uche AKPA.
I love his food, though.
Okay. That will conclude our speakers list.
Motion to close.
Excuse me. Moving on to our petitions and communications. I have 2 petitions communications to add to tonight's meeting. One by Sam Pessin and the other by Trevor Batcheldeller. They'll be added to the agenda. So that would be items 6.1 through 6.16. Any questions or comments? There are no office communications, no report of directors, and moving on to our claims. And addendum number 1. Council members, I'm going to be taking a vote on claims and addendum number 1. Councilperson Ridley.
Aye.
Councilperson Prinzeri.
Aye.
Councilperson Baggiano. Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore. Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman. Aye. Claims and addendum number 1 are approved unanimously, 9-0. On to our resolutions. I'll be taking a vote on items 10.1 through 10.13, with the exception of 10.13, which has been withdrawn. So it's items 10.1 through 10.12. Councilperson Ridley.
I just want to say on 10.5, this resolution is in honor of one of the reverends that's very instrumental in the Haitian community. He was a reverend at the big church on Kennedy Boulevard across the street from NJCU, the Blue Front Church. And he also did a lot of work with the city in regards to the Haitian community and some of the recent occurrences. So condolences to that family and rest in peace. And with that, I vote aye on all.
Councilperson Prinzeri.
Raw.
Councilperson Baggiano.
Aye.
Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
I have to abstain on 10.11. It's my place of work, but aye for the rest.
Thank you. Councilperson Rivera.
Abstain on 10.11, aye on all the rest.
Okay. And Council President Waterman.
Aye.
All right. Items 10.1 through 10.10 are approved unanimously, 9-0. Item 10.11 is approved 7-0-2, with council members DeGise and Rivera abstaining. Item 10.12 is approved 9-0. Item 10.13 has been withdrawn. Next set of resolutions, items 10.14 through 10.22, with the exception of 14, 15, 16, 17, 20, and 22, which have been withdrawn. So we are voting on items 10.18, 19, and 21. Councilperson Ridley.
Aye.
Councilperson Prinzary.
Aye for all.
Councilperson Baggiano.
Aye.
Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
You said 18, 19, 20, and 21, correct?
So we're voting on 18, 19, and 21.
21, aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman. Items 18, 19, and 21 are approved unanimously 9-0, with items 10.14, 15, 16, 17, 20, and 22, which are withdrawn. On the balance of our resolutions, items 10.23 through 10.34, with the exception of 10.23 and 24, which have been withdrawn. Councilperson Ridley.
Aye.
Councilperson Prinzary.
Aye for all.
Councilperson Baggiano. Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Apologies, Sean. Can you say them again, please?
Sure, don't be sorry, it's fine. We're voting on items 10.23 through 10.34, with the exception of 23 and 24, which have been withdrawn.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman.
Aye.
Items 10.25 through 10.34 are approved unanimously 9-0, and items 23 and 24 have been withdrawn. With that being said,
Motion to adjourn.
I have a motion to adjourn made at 7:50 p.m. made by Councilperson Rivera. Was there a second I heard?
Second.
That's what I thought. I apologize, Councilperson Saleh. Second made by Councilperson Prinzary. On the motion to adjourn at 7:50 p.m., Councilperson Ridley.
Aye.
Councilperson Prinzary.
Aye.
Councilperson Baggiano. Councilperson Saleh.
Aye.
Councilperson Solomon.
Aye.
Councilperson Gilmore.
Aye.
Councilperson DeGise.
Aye.
Councilperson Rivera.
Aye.
And Council President Waterman. Motion carries 9-0 to adjourn at 7:50 p.m. Thank you very much, Council President, members of the council,
Mr. Clerk, take us home.
and professional staff over there. Teamwork makes the dream work. Have a great night. Stay safe.